The committee will now come to order. The committee is meeting today to hear testimony on H.R. 560, legislation I introduced to address the loss of the humanitarian parole that was granted to certain long-term Marianas residents by the Obama administration. We will also hear from our witnesses about the impacts on the Mariana Islands and Guam on the removal of the Philippines as one of the countries eligible for the H-2B worker visa program. Under Committee Rule 4F, any oral opening statements at hearings are limited to the chairman and ranking minority member. Therefore, I ask unanimous consent that all other members' opening statements be made part of the hearing record if they're submitted to the clerk by 5 p.m. today. Hearing no objections, so ordered. Additionally, I ask unanimous consent that I will have two additional opening statements after the chair and the ranking member make their statements. The committee chair and the committee ranking member, full committee ranking member, will also make opening statements. Without objections, so ordered. Before we begin, I want to thank Chairman Grijalva for making insular policies like those on today's agenda a matter of full committee jurisdictions. This was what's called the Interior and Insular Affairs Subcommittee. So we're really returning to a tradition that recognized the importance of almost 4 million Americans who live in non-state areas of our nation. I also want to thank my fellow members of the committee's Democratic Caucus for selecting me to be Vice Chair for Insular Affairs. With Insular Affairs, issues raised in importance, and with a representative from one of those insular areas, the Marianas, driving the agenda, I look forward to a very productive 116th Congress. Last but not least, I want to remind everyone of another tradition of this committee, taking a bipartisan approach to insular policy. We saw that bipartisan commitment demonstrated by Chairman Bishop last year when he pushed my Northern Mariana Islands U.S. Workforce Act over the finish line. I remain very grateful to him, and he certainly has my commitment to continue to work to use the bipartisan approach to insular policies that he so clearly demonstrated. I just sometimes don't get his jokes.
Youth a sense of humor. You're not alone.
Well, when this committee passed and Congress enacted Public Law 110-229 to extend U.S. immigration law to the Marianas, Congress explicitly stated the intent to minimize potential adverse economic impacts. In accordance, the Obama administration, beginning in 2009, granted humanitarian parole to certain CNMI permanent residents and their immediate relatives of freely associated states and U.S. citizen caregivers, and U.S. citizens, caregivers, and certain stateless residents of the Marianas. Their circumstances have not been taken into consideration in Public Law 110-229, and their presence in the Marianas in many cases had important economic effects. Unfortunately, on December 27, 2018, the Trump administration announced the termination of these Marianas-specific parole policies without warning and gave those Marianas residents previously covered 180 days to leave the Commonwealth or find some other status. H.R. 560 would reverse the Trump administration decision and provide permanent status in the Marianas for those persons, as well as for certain long-term workers and investors. I want to make clear that, as with my previous bills on this subject, H.R. 560 only covers people who were lawfully admitted to the Marianas and who have remained lawfully present throughout their time of residence. No amnesty. H.R. 560 provides no new eligibility for public benefits and adds no new societal costs. Instead, by stabilizing the population and the workforce, H.R. 560 will have a positive economic effect. At this time, I request unanimous consent to add to the record a February 21st letter to Chairman Grijalva from Assistant Secretary Christine Ciccone, expressing the Department of Homeland Security support for passage of H.R. 559 and saying the administration has no concerns on this matter. The same letter was sent to Ranking Member Bishop and myself. H.R. 559, like 560, provides permanent status in the Marianas, but only to those who are losing parole, not to long-term workers and investors. Nevertheless, I thank the administration for this partial support. The Trump administration also announced a month ago that it was removing the Philippines from the list of countries eligible for H visas. This decision is effective nationwide, but it was made without consideration of the Marianas. The Northern Mariana Islands U.S. Workforce Act, which I mentioned at the outset, this committee so successfully through to enactment last year, specifically relies on unlimited H-2B visa holders to supplement the Marianas workforce, as the number of CW Commonwealth-only transitional workers is reduced over the next decade. The elimination of Philippines is essentially poor time as reconstruction from recent typhoons is underway, and there is critical need for construction workers to repair and rebuild homes, schools, and infrastructure. Guam, our neighbor to the south, is likewise facing difficulty in its civilian construction workforce and its healthcare industry due to a labor shortage that is exacerbated by the new federal restrictions on Filipino workers. Information we received today will inform the committee and will inform legislative action if necessary on the visa waiver issue, and I look forward to working with Chairman Grijalva and my committee colleagues to mark up HR 560 quickly and move it to the floor. I now recognize Ranking Member Gonzalez for her opening statement.